GAO's fraud investigators created 4 phantom companies, including 2 with mailboxes as a principal office and a third with a Starbucks as the principal office. Are these 4 companies still listed as eligible HUB zone firms?
As of 8 a.m. this morning, yes.
Administrator Hurston, why was the SBA unable to even find the phony HUB zone firm at a Starbucks? And why weren't you able to?
Well, I'm sure if in fact those firms are in fact in the system now, that there is a process ongoing to remove them. There is a decertification process. I would hope that that process is underway. I can get that information back to you.
But
they're not being decertified. No, I mean we would have gotten notice. I mean we haven't heard anything from SBA at this point for those 4.
But isn't this firm the same one that was found to be ineligible last July?
No, those are our 4 fake firms that we're talking about.
Yeah.
Versus the one that actually got $23 million of new contracts. So, but no, our bogus firms are still in the system. Although we haven't competed for contracts, we're not really willing to go that far with it at this point.
Yeah, and I would agree that they should not be there.
Really? 10 cases were brought to your attention last year. Only 2 have been officially removed from the program, and none have been debarred today. I have read your testimony and your explanation for this. Given the seriousness of the violations, why did the SBA not choose to suspend these companies during the debarment process?
Because we don't have the authority under our regulations to suspend prior to a formal action. Differing from our 8A program, under the regulations in our
Mr.
Section
Scheer,
8.
is that correct?
No, that's not correct. You can suspend a company before there's a prosecution and indictment if you have sufficient evidence. I mean,
And do you believe that there is sufficient evidence?
I would actually disagree with that. I would disagree with that, and our counsel would disagree with that. We don't have the authority. It's not specific in our regulations that we could actually suspend prior to a formal determination. We can do that in the 8A program. We have specific requirements under our regulations in the 8A program that allow us to do that, to preclude a firm from receiving benefits for which it's not eligible. That's
I want
flaw.
for your counsel to put that in writing for the record and send it to this committee.
Yeah, Madam Chairman, I just make for the record, I'm talking about suspensions, not debarments. Debarments require a much longer process, but suspensions can be done without as much evidence. I mean, if there's enough evidence in this case to decertify, our position would be that they could be suspended.
And we rely on our counsel who says
That they cannot be suspended?
that there is an evidentiary procedure and standard that has to be met, and that there's a due process afforded in that process. That's why I was explaining the difference between the authority we have under our 8A program that differs from the authority we have under our HUB zone program. But we will provide you what you're asking for.
Mr. Kutz, why do you believe that there have been so few referrals for either suspension or debarment?
As I mentioned before, because I think before you had more of a self-certification process, and so hopefully if they're putting more stringent front-end controls in place, they will identify more cases that actually they would refer to the IG and that they would consider for suspension and debarment. So hopefully if you move from an environment of self-certification to one where you've got effective controls in place, you will come up with more examples. And I would just say for the record, too, here, and I think Mr. Bartlett mentioned it, too, I think you have to make some examples of people. And if you don't make examples of some people here, you're not going to have any change. So here we are nearly a year later from our hearing last July, and we have little or nothing that's happened to the 10 cases before. And I would say some of those were egregious fraud cases that, again, I would say for the record, could have been suspended by now. We're talking about 6 or 8 months after the last hearing. The fact that nothing's been done with some of those companies and they're still getting government contracts as HUB zone companies is not a good sign.
Any comments to that?
Oh, well,
Quite a
out of the
statement,
10
sir.
cases that were referred, I think I indicated that we found 3 of those firms to be eligible. 2 of the firms were decertified.
What about the other 7?
I'm explaining that. 2 of the firms were decertified, 2 of the firms withdrew from the program, and 3 are actually still under investigation, and 7 have been referred for suspension and debarment.
Mr. Kutz, did you get any information regarding the 3 firms that SBA claim are eligible?
No, we've asked
that
for
effect?
information. The 3 cases were 3 cases, I believe, that they failed the 35%, not the principal office requirement. At the time we looked at them, we determined, based upon payroll records that we received, that they did not meet the 35%. SBA has represented that they now do, or at some point in time when they did the investigation, they did. We asked for support for all 3 of those cases about 2 months ago, and we've not received it yet.
Why is that?
I will find out. I don't know the answer to that. I wasn't aware that that request had been made, but I will find out why they haven't gotten the information.